Okay, it's Law of the Weird time again. Good day to everybody. I've got my Florida Gators hat on today, marking the beginning of the college and pro football seasons. Don't forget to watch your favorite team. This is Tom Swanson here from Houston, Texas. I'm a lawyer, and for a long time I've been reading appeal court decisions and wanted to share with you uh, you know, decisions involving weird stuff to let you know that, the law is interesting, that sometimes it's stranger than fiction. Sometimes it's just plain weird. So here's what got for you today. We've got Twyman versus Twyman, which is a Supreme Court of Texas case from 1993, okay? And basically, it involves important issues in the law. And let me give you the rundown. Mr. and Mrs. Twyman were married in 1969, and in 1985, Ms. Twyman filed for divorce. Okay, big deal. Except it became a big deal for this reason. Ms. Twyman also, in addition to the divorce, you know what I mean by the divorce, you end the marriage, you divide the property. If there are children, you get into custody and support and all that kind of stuff. But Ms. Twyman added a personal injury lawsuit in the case, namely asserting that Mr. Twyman had caused her emotional distress because he was engaging her in deviant sexual acts. Now, that's not described in any detail in the case. I'm sure we're all wondering what that meant, but we'll just have to be deprived and just, say that the court described it as such. The trial court awarded her, in addition to the divorce and other things, awarded her $15,000 as damages for the causing emotional distress to Mrs. Twyman. Well, this case went up on appeal, ultimately landing at the door of the highest Texas state civil appeals court, the Supreme Court of Texas. Because at the time, the Supreme Court in Texas was dealing with a lot of issues where they were faced with making very important decisions. One had to do with, the issue of immunity to be able to, from being sued by your spouse. Since the 1700s, first in England and then later in Texas, one spouse could not sue the other. Okay, the idea was, first of all, that in the 1700s, the argument is that when you married somebody, you all became one, and hence you couldn't separate for the purposes of suing. There were other reasons later that argued that you shouldn't have, one spouse shouldn't be able to sue the other. It would cause disharmony in the home. Imagine that. You think that would happen? One spouse sues another? It might. Another reason was offered, and that is the spouses would get together and collude and create all kinds of false lawsuits. So, bottom line was, the Supreme Court was trying to figure out what to do with this spousal immunity thing. They had decided in one case that spousal immunity wouldn't apply in a case involving an estate. But at any rate, this really was an important case, Twyman was, because, you're talking about one spouse adding a personal injury claim to the divorce case. What was going to happen with that? What was going to be the blowback if you could do that? Okay, back to the case. The Supreme Court, first of all, recognized that there were two kinds of emotional distress claims that were being considered by the court. One was for negligent infliction of emotional distress, and of course, negligence is accidental but careless misconduct. And the other was intentional infliction of emotional distress. Now, this is kind of a different animal. Remember, something that's intentional is on purpose. But intentional infliction of emotional distress is more extreme than that. That first of all, the conduct must be outrageous, okay, and be the cause of severe emotional distress. And I will tell you, the court kind of its approach to this is we know it when we see it. But the point is this: the Supreme Court ruled that they were not going to consider claims for negligent infliction of emotional distress. They weren't going to go there. Okay, they had already decided that issue in another case, so they weren't going to revisit it. But here's the kicker. First of all, they were authorizing in this decision in claims for intentional infliction for emotional distress, and authorizing it in a divorce case where one spouse was suing another. So the bottom line is they were saying, look, there's not going to be spousal immunity in these situations, okay? So as a result, now, if you're married and your spouse sues you for divorce, there might be a personal injury claim brought as well, for actual damages. So beware, don't get your spouse too upset. Okay, weird enough for you? I never did find out what this deviant sexual acts thing was, but we'll just have to live with that. Okay, have a great day. Go Gators.